Hello, everyone. Welcome back to another season and episode of the Public Law Parlour. I say season because this is season two. We're now in 2026, so we had to bring out a whole new season for you guys. Of course, as usual, we took a break and we're back here again. I know we always say that, you guys missed us for quite some time, but this time was longer than usual. It has been months, but we are glad to be back here with you and that you're back here with us. And I have my co-host, Alexander Ramdas, here with me. As usual, Alex, I'm sure that the listeners and our supporters have missed hearing your voice, so you can say something for them.
Hello, everyone. I'm glad to be back for season two of the Public Law Parlour. It has been about 5 months. We won't go into the reasons for our absence, only that season two took a while to make, for many reasons. Discussions with our producers being the chief amongst them.
Funny, funny guy. But before we delve into this episode, guys, and this new season, we would like to have a brief moment of silence in honor of someone who was close to both me and Alex. His name was Daquan Roberts. He was a law student in the Faculty of Law at the University of the West Indies Cave Hill campus, who tragically lost his life to senseless gun violence in Barbados a couple months ago. And he was also a former student of mine. Alex got to meet him virtually and eventually in person as well. And the reason why we are having this brief moment of silence is because he was also an avid listener of this podcast. And we just want to have that brief moment of silence starting now. Rest in peace, Daquan Roberts. So, guys, we have a very interesting topic to discuss today. That is the state of states of emergency in the Caribbean. And we chose this topic because it seems to be very topical right now, and it has been for quite some time, especially in recent years. And we just want to lay the foundation here. We're going to look at the general principles pertaining to states of emergency, especially in the Commonwealth Caribbean. And then we're going to look at two practical examples of how they were used in our region, namely with the COVID-19 pandemic, and then now with the upsurge and increase of gang related and gun related crimes in the Caribbean. So, general principle. So, what is a state of emergency? So, generally, a state of emergency is viewed as a phenomenon that threatens, undermines, or severely affects the security, the sovereignty, or the entire life of a nation. And to my mind, that speaks to the severity of the threshold that has to be reached in order for a situation to be deemed an emergency in the first place. Now, what is the purpose of a state of emergency? So, usually, the purpose of a state of emergency is to get control of the particular situation at hand that is so grave that you had to declare the state of emergency in the first place. So, it could be, let's say, a war, it could be a pandemic, it could be the spread of infectious disease, and we will get into those in detail later. what can be done and what cannot be done. So, for the purposes of this podcast, where we're looking at public law, constitutional law, human rights, etc., the main thing that the state is allowed to do when it declares a state of emergency is suspend human rights in our Caribbean constitutions. And when we speak about suspension, we're really speaking about limiting those rights. It's not that you don't get to enjoy those rights at all, but you do not get to enjoy them to the degree that you usually would in the normal course of things. Now, there are certain rights, and this speaks to the what cannot be done. There are certain rights, however, that regardless of the situation, whether is in a state of normalcy or a state of emergency, that cannot just be suspended at all. So, for example, the right not to be subjected to torture. You cannot torture someone even if you're claiming that it's a state of emergency. The state does not have that power. Let's say the right to a fair trial. Even if you arrest someone, you charge them, you cannot affect their right to a fair trial if it goes to that stage simply because of the state of emergency. And then there are other due process rights as well. So right to an attorney, and all the other procedural rights that would come with any interaction with the criminal justice system. Now, who declares a state of emergency? Typically, and I think this is the principle throughout the entire Caribbean, the head of state, whether it be a president or governor general, depending on the system of government that the country has, declares the state of emergency. And in most cases, if not all, the head of state is acting not um, on his or her own discretion, but usually on the advice of the head of government, who would usually be the prime minister. Unless, of course, is a situation like the one in Guyana, where the head of state is also the head of government. How long can it last? Well, it depends on which constitution we're looking at in the Caribbean. In some instances, a state of emergency can last for 3 months in the first instance. It may be less, it may be more, again, depending on the particular Caribbean country. And after the first instance, the government usually does have the power to extend the state of emergency, but that usually means that you have to go to parliament in order to get that extension. So it must be voted upon in the House or Houses of Parliament. And then there are obvious limits on the exercise of powers during a state of emergency, on executive power. So, like I said, it's only a suspension of rights, but not a complete eradication of them. On top of that, you still have to comply with certain constitutional principles like separation of powers, the rule of law, legal certainty, the principle of proportionality, meaning that whatever measures you decide to implement during a state of emergency must be proportionate to the aim you are trying to achieve. And the aim is usually, generally speaking, a return to a situation of normalcy, right? Going back to what the situation was before the emergency occurs. So, with that being said, and laying the foundation with those general principles, let us go to the first practical example, Alex, that we had in the region recently, and by extension, the world, where the COVID-19 pandemic affected the entire globe and how we dealt with that situation. Now, of course, you know that there's no doubt, and there could not have been any doubt, that the COVID-19 pandemic did constitute a public health emergency, and therefore states were empowered and enabled to declare states of emergency. How they were declared throughout the entire Caribbean and the rest of the world, I guess, varied from country to country. Some countries relied on the emergency powers in the Constitution. Others relied on emergency powers in ordinary legislation, which they're generally allowed to do. Now, there's so many different things we could say about the COVID-19 pandemic and how it affected fundamental rights. I am of the opinion that the COVID-19 pandemic and the emergency powers that were utilized during the COVID-19 pandemic affected almost every single right in the Constitution at some point in time, literally. Uh, and we have a few cases here, two from Trinidad, and we're not going to go in depth. We're just going to say, well, what the facts were and essentially what the court found. Two cases from Trinidad dealing with the state of emergency in Trinidad during that point in time. So the first case is the case of Dominic Suraj and others and the Attorney General. And this case related to emergency regulations that were passed, essentially putting a limit on gatherings that could be had during the COVID-19 pandemic in Trinidad. So it limited obviously your right to freedom of movement, freedom of association, assembly, and what's not. So and under these regulations, Dominic Suraj and some others, they were arrested, they were detained, and ultimately they challenged these regulations on the basis that it infringed separation of powers because they were saying that one minister was allowed to pass these regulations without any parliamentary oversight and what's not, and that the regulations were disproportionate to achieving the aim, which was to curb the COVID-19 pandemic and so forth. And they were not successful. The court ultimately disagreed with them and dismissed their appeal. It went all the way up to the Privy Council, and their appeal was dismissed. Obviously, another thing to note here is that during states of emergency, the courts usually afford a margin of appreciation, meaning that they give the executive branch of government more latitude to do what they have to do in order to curb the situation or to control the emergency. So they're more deferential to the state in this regard. Um, because the presumption is that the executive branch of government will be better placed to deal with those kinds of situations that affect public safety, national security, and what's not. And therefore, the courts must give them some kind of deference and leeway to deal with it because that's what they were elected to do. So obviously, that's one of the principles that I'm sure the court was guided by in reaching its decision in Dominic Suraj. And then you have another interesting case, which is the case of Lorick and Pantin and the Attorney General of Trinidad as well. This case surrounding the issue of when the COVID-19 pandemic first came to Trinidad and it caused a lot of Caribbean countries to close their borders, Trinidad and Tobago being one of them. And the result of this was that there were citizens of Trinidad and Tobago outside and inside who couldn't get back into Trinidad or they couldn't leave Trinidad. And this case dealt with two Trinidadian citizens who were outside, and because of the closure of the borders, they couldn't get back in. Um, the regulations allowed for the Minister of National Security to grant certain exemptions to people to either come in or go out, despite the closure of the borders. These claimants, they wrote, sought exemptions, but the exemptions were never given. And the criteria for the granting of these exemptions were never published to the public as well. So it raised issues of, lack of transparency, arbitrariness, etc. So they brought constitutional motions. They were saying that their rights to liberty, protection of the law, were infringed in these circumstances, and the court did agree with them and found that their constitutional rights were violated. So it just goes to show that there are circumstances where, even though the courts give deference to the state to do what they have to do to get control of the situation during a state of emergency, and there's this margin of appreciation, the court still will not hesitate to invalidate certain measures when the government goes too far. And we saw that in the case of Laurie and Pantin, though in Dominic Suraj, the court found that, nothing was wrong with the regulations and the claim was unsuccessful. But that is probably around like 2, 3, in some instances 4 years ago. But we now have a situation, Alex. And Alex is the best person to speak about this because he was actually involved as a litigator in some of these cases. He's a very prominent figure now in Belize, I would say, when it comes to these types of matters. But we have a situation now where the COVID-19 pandemic, for all intents and purposes, is now gone. And what we have and what we've had for many years is an upsurge in gang related and gun related violence. And what a lot of Caribbean governments are doing now, we see it now in Trinidad and Tobago, we've seen it in Belize, we've seen it in Jamaica, is that they're using the state of emergency powers as a means of tackling gang violence and gun violence. So Alex would tell us, well, he would essentially put everything to perspective. He would contextualize everything and let us know what the courts have been saying in that regard. And after that, we will have a very general discussion about, if the courts were right, if they were wrong, if these Caribbean countries were right, if they're wrong, etc. So Alex, over to you.
I am far from a prominent figure in Belize. I am merely a junior counsel. Um, but thank you, Rico, for that explanation. Very, very detailed and informative as usual. Um, to begin, I'd like to lay what I would consider the necessary groundwork to discuss this, because each of these cases are not really fact specific in the sense that the cases that I have to mention all address the same question, and that is the circumstances in which a state can declare a state of public emergency to address crime. I'd like to believe that the majority, if not all, of our listeners are from the Caribbean region and experience on a daily the increase in gang violence in our respective countries. It is something that is prominent in Jamaica, prominent in Trinidad, prominent in Belize, and all across the region. Regional governments have been posed with a problem of an increasing number of gangs and gang warfare in their countries. And since just after the pandemic, I'd say, there has been a noticeable trend of regional governments relying on the mechanism of a state of emergency as a means of suspending rights, suspending constitutional safeguards, such as the need for warrants, in an effort to curb gang violence. Now, our discussion today will not finish today, but will extend to several other episodes, because what we are doing is discussing cases coming from 3 principal jurisdictions where the question of whether states of emergency can be used to address crime have begun or have been ventilated or in the early stages of ventilation. And what that means is that there's been a lot of lower court, meaning high court rulings on the matter. And what you find is that regional courts have identified certain trends, but also some key differences that make for interesting discussion and are also very relevant to the realization and recognition of human rights within the. Nevertheless, to begin my discussion on the cases, I think it is important to identify what I think is the forefather case, or the case that that started it all, which would be the case of Earl Ely against the state of Trinidad and Tobago, or the AG of Trinidad and Tobago, which was um, a challenge to the 2011 state of emergency declared in Trinidad and Tobago, on the basis that there was a rise in violent crime that threatened key institutional actors within the country, meaning members of parliament, the police, um, members of the judiciary. Um, the court in that case, as Rico would have alluded to, hinged heavily on a judicial deference to the judgment of the executive in matters of national security. So what that meant is that the court did find that crime or rises in crime can be determined to be a state of emergency. But what was important was that the court put a bit of a proviso in that the state had to produce evidence of an exceptional threat to public safety. Moving now to the country where I'd say this drama kicked off, in the region, and that would be Belize, where recently there was a split in the High Court, on whether states of emergency can can be used to address rises in crime. And in Belize, there are three cases: Jareem Stain against the AG of Belize, Demetrius Gordon against the AG of Belize, and the case that I was a part of, RT, against the Commissioner of Prisons and the AG of Belize. And what the Belize situation brought about was a clear distinction in judicial perspectives. In Demetrius Gordon, Gunatilaki J, who's a Sri Lankan judge, he gave absolute deference to the executive's power to declare a state of emergency and did not entertain in any way the court's role in assessing what a state of public emergency was.
And
Injury,
just to stick a pin there,
yeah,
Alex, I think you see, and this is the point that I was alluding to earlier. You said absolute deference. The word
yeah,
absolute suggests that he completely ignored the court being the guardian of the Constitution. And
yes,
therein lies the problem is deference, but it's not supposed to be absolute deference. It has to be a balancing act of the different roles and responsibilities of the judiciary and the executive. Right. So
yeah,
that's quite interesting that you mentioned that.
yeah. So I mean, the judgment is online, if you're welcome to read it. But if you read his judgment, you'll find that there was no interrogation or appreciation of that guardian role that you were talking about. That there seemed to have been the judgment read like, well, the declaration of states of emergency is a executive function, and my role as the court is not to cross into that line and interrogate,
Or
um,
to not question the
to not to
powers
question. Yes. What
exercised thereon.
what you what you do have though, in the two latter cases, Jareem Stain against the AG of Belize, and RT, is an application of the Earl Eli principle in that there is a need or an acceptance that yes, the state or in some circumstances, crime may warrant the declaration of a state of emergency. However, what the court, the just discretion of the court to determine whether the state of emergency was validly called depended on the open evidence of the case. So the distinctions between RT and dream stain, and we'll get into these distinctions more substantively in future episodes. But in sum, the distinction between those two is that in dream stain, the court was of the opinion that insufficient evidence was provided. And in RT, which I think was wrongly decided, that there was sufficient evidence.
But RT wasn't wasn't RT the case that you were involved in, Alex?
Yes, that's
Why
exactly
are
the
you
case.
saying why
Um,
are you saying that it was wrongly decided?
well,
To the best of my knowledge, it was decided in your favor.
it was decided on my favor on some counts. On the question of whether the state of emergency was wrong, the court found that the state had produced sufficient evidence of a rise in gang activity, connected gang activity. I disagree with the court's assessment of the factual evidence presented to her. Um, but as I
Are you
said,
disagreeing? Are you disagreeing with the court because the court rejected your argument or
I,
submissions?
I am disagreeing with the court because I felt like it was a bit arbitrary. So part of the part of the state's evidence in that case, um, I don't know if I'll keep this in or not, but part of the state's evidence in that case felt like a bit of sporadic gang violence. Like two people had a fight over a woman, and like there was no. So in Trinidad, in early life, for example, the evidence produced, at least the intelligence produced, was a consolidated threat towards key members of the of society.
As
So like
in there was consistency or
yeah, or a
frequency
various threat,
in
a big threat. Like there was
yes.
a
All
threat
right.
towards the judiciary or the DPP or
Okay.
a member of parliament or senior police officers. Um,
Okay.
in RT, I don't think the evidence met that threshold. Like a lot of the intelligence
Okay.
put before the court seemed a bit unconnected and sporadic. The court itself found a connection, and the court is entitled to look at facts and draw their own conclusions in the way they want to. Um, but I personally didn't. I didn't draw the same conclusion looking at the facts presented before it.
Okay. Well,
Um,
well, tell us about your successful point. Which point did you actually
oh,
succeed on?
So the point we succeeded on in RTE was the rights of a child in the Belizean penal system and the duty that the state owed to our child. So RTE was a 13-year-old boy detained under emergency powers declared in Belize, and he was held in the Wagner's facility, which is an adult facility, um, in conditions that were basically solitary confinement or akin to solitary confinement. Um, so if you are familiar with your international law and your ICCPR and all of these things, and the Convention on the Rights of a Child, especially juvenile offenders, you know that under the law, under the Constitution, under the international law, you're not allowed to treat a child offender as an adult. Um, and the treatment of a child as an adult comes with various constitutional implications that were entirely ignored. Um, so
Even during a state of emergency,
even
you're
during a
not
state
allowed
of
to do that.
emergency,
Right,
yes,
which ties
even
back
during a
into the
state of
point
emergency,
that we were
yes,
making earlier, which is that
yes,
suspension of the normal operations in the state or of certain rights does not mean that you get to do everything whimsically or arbitrarily,
yeah,
as some governments clearly do.
yeah,
So even during the state of emergency, there are limits on those exceptional executive powers you can exercise.
yes. Yes, thank you. So, yes, but in the principal discussion and the point I wanted to win on, and I guess my colleagues and my senior lawyer on the team wanted to win on was the question of whether whether a rise in crime amounts to a state of emergency and to set an applicable threshold for what that means. Because if you'd realize something that I hopefully explained clearly in discussing early Eli, Jareem Stain, and RT, is that the courts have not set, and maybe for good reason, a threshold, but they have not identified a standard of evidence. So what you have emanating or evolving is probably the better word, is a judicial principle where we can interrogate to some extent the reasoning for the state of emergency, but there's no way of testing the evidence or ventilating whether this emergency is legitimately called. And why I say that,
Wouldn't you say though? I mean, and I'm being devil's advocate
yeah,
here. Wouldn't you say that the case from Jamaica, Dayton Campbell and the Attorney General actually set some kind of threshold
yeah,
though?
yeah. So I was getting there,
Right.
Mr. Yearwood, if you want to jump the gun. But Jamaica is one country in the region, and and and, and clearly, it has not been followed as yet, by any
So
of,
I guess perhaps we should tell our listeners then why
yeah,
Jamaica is considered somewhat of an outlier in this
yeah,
context.
yeah. So, but I'll circle back, right? But what you have emanating, right, is some questions that are emanating that evolve, right? The courts have sort of settled on the position that yes, crime can be something that warrants the declaration of a state of emergency. However, it needs to be assessed on the open evidence of the case, and there's a lot of judicial deference given towards the executive's role in declaring that. However, moving to Dayton Campbell, as Rico would have mentioned, what we see, I think, is what a very good judgment coming from the courts in Jamaica, where I think quite correctly they've assessed the situation as it is in the Caribbean, and they've understood that the the declaration of a state of emergency has become a bit of a tool and a bit of a crutch that regional governments have used to address the rise in crime problem. Um, Notably, in Dayton Campbell, what the court identified was that there were 17 states of emergencies declared since 2018 in Jamaica between 2018 and 2023, when the case would have appeared before the High Court. And what what the court what the court did to me is quite revolutionary, um, because they engaged in constitutional interpretation that I think spoke to the reality of Caribbean society, in the sense that they gave an interpretation of the Constitution that was workable, realistic, and not bogged down by constitutional norms such as judicial deference to executive decisions. And there was an assessment of the facts of the case before it. Because one thing that the court in Jamaica highlighted, um, was that they did not deny that crime was a serious problem. However, they were quite clear in asserting that the rule of law required that for an end to be pursued, it must be inherently justifiable. And what that means is that a state cannot say that, or a state cannot rely on the fact that a state of emergency has reduced crime as evidence of calling another state of emergency, right? So that's quite revolutionary because anybody on the street or anybody objectively assessing the situation as it is in Trinidad, in Belize, in Jamaica would know that you declare a state of emergency as a visceral gut reaction as government, I'm speaking, to a rise in crime. And I think it's brilliant because when you say that the rule of law um requires requires that that for an end to be pursued, it has to be inherently justifiable. You can't now ex post facto look at the results and say we did this because of this, right?
So
Um,
not essentially a retrospective analysis then.
yeah, yeah, and we are trying to get somebody from Jamaica to come to speak in more detail. Um, but but in essence, the Jamaican court found that found that using the factual circumstances that exist in Jamaica, where there were 17 states of emergency in a 5-year period, right? They were of the opinion that a state of affairs that exists over a large period of time inherently cannot be described as an emergency.
Why is that?
Because, because if a state of public emergency is by itself limited within the Constitution, right? You have a constitutional limit. You have to declare your state of emergency after 14 days. You go to Parliament, and by majority of Parliament, you vote to extend it for a further 3 months or whatever the time may be, right? If you have a if you have a system in place where you basically declare a state of emergency, wait for the time limit on that emergency to expire, and then shortly thereafter declare another state of emergency for similar, but not entirely, but somewhat different reasons, all connected to this gang violence problem. What you're doing, and what the court quite correctly assessed, is you're now using your emergency power regulations as a subversion of the parliamentary process. Because in all of this time that these emergency powers are in effect,
Isn't that different though, Alex? Where you're not going back to Parliament as constitutionally prescribed to seek Parliament's approval for the extension of a state of emergency. I mean, that's a clear violation of separation of powers, which is what the court in Dayton Campbell found. But let's say you have a situation where you're going back to Parliament as a government, you're getting the approval from Parliament to extend the state of emergency. Can there be anything wrong or constitutionally illegitimate about that?
constitutionally illegitimate of going back to Parliament to
To extend the state of emergency?
no,
Because
there's nothing.
you seem to be premising your argument on the fact that if it has been going on for a certain amount of time, let's say 5 years, as in Dayton Campbell, that it can no longer be deemed a state of
No,
emergency.
no. So
Is
the
that
thing
what you're saying?
is not a that is not what I'm saying. So the practice is that remember all states of emergencies have in some sense a time limit, right? because you have to go back to Parliament to declare the same state of emergency, right?
Right, but you
Right, but
see, and that is one of the problems I have. That is
yeah,
constitutionally speaking, there's a time limit, but technically, because of the power to essentially extend in perpetuity or for as long as you want, is there really a time limit?
yeah. So what the practice that has evolved, and I think this is the practice that they were speaking to in Jamaica, is remember there were 17 states of emergency in 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 the space of 5 years. So there were 17 separate declarations, right? So the the situation or the circumstances evolve, right? Or evolve in inverted commas. Um, but but so that's what I'm saying is that it is constitutionally feasible to go back and extend one emergency for an extended period of time on the premise that that emergency continues, right? And you have to go to Parliament and validate that emergency. For example, the emergency state of emergency that was called in, I believe it was October of this year, October of last year, sorry, in Trinidad, was called on the premise that there was uh, uh, there was intelligence that there was activity or coordinated activity within our prisons that was geared towards threatening various members of society, politicians, police, prison officers, whatnot, right? The reason for that declaration in October and its extension to January is different from the reasoning of the state of emergency declared in March, 2 months later, right? The declaration for the state of emergency in March was increasing gang violence, same high ranking members of society, as they say. Um, and as I understand Dayton Campbell, what the court is saying is that the that the use of an emergency power provision or the use of this emergency power provision to address what is fundamentally a similar situation happening over a long period of time cannot be an emergency.
But do you agree with that, Alex? I'm not so sure that I agree with that. Let's transpose that principle to, let's say, the COVID-19 pandemic. Weren't countries doing that during the pandemic era as well? And wasn't it justifiable?
They were doing it during the COVID-19 pandemic, but the COVID-19
Right,
pandemic,
exactly. So
yeah,
therein lies my problem, because the only difference then would be the nature of the threat.
yeah, that's what I was saying is that
So
it's a question.
it still constituted an emergency, even though it was going on, let's say, for 2 years into 3 years. So I'm not so sure that I'm following your point and the analysis of the court in Jamaica.
Yeah.
So I that's the point I was trying to make all along. So how would you respond to that? So I think you must agree that there is um some kind of a difference between how the emergency powers were utilized during a situation, let's say like the COVID-19 pandemic, and how they're being utilized by regional governments now to deal with the upsurging violent crimes. You would agree?
I would agree. I would agree, but it's a question of the nature of the emergency, as you indicated. Um,
Okay, so
yeah,
you're agreeing with my point then, which is quite rare, but
yeah,
you know, I,
yeah, but it's a
okay.
nature of the emergency, and also there needs to be, in some respect, an assessment of the objective and the aim. If you go through the the Oakes test,
The
in that
proportionality test.
proportionality test, yes, in that
Yeah,
the
I think one of the striking differences in Dayton Campbell in Jamaica is that what the government was doing is that the government was realizing that it couldn't get parliamentary approval for continued extensions, and therefore it would wait a few days
Yes.
before it declares or declared another state of emergency. And the court said, no, that's a clever way to essentially circumvent the separation of powers doctrine. There exists in the Constitution a procedure or process for extending states of emergency for a reason. And by
Yes.
you taking a couple of days, then to implement another one after those days pass is a very clever and
Yeah.
conniving way to get
Yeah.
around the separation of powers doctrine, which I can agree with, but I'm not so sure that I agree with the court insofar that it found that simply because it continued a situation or state of affairs continued over a long period of time that it can no longer be classified as a state of emergency.
Well, I
Because
mean, in
one of
some
the things
sense,
the court
in
looked at is the definition of a state of emergency in the Oxford Dictionary. And it
yeah,
essentially said that an emergency is something that's sudden. And the court saying, well, this can no longer be considered sudden or immediate because it has been going on for so long.
yeah, but
And I'm
I
not
think
so sure
is
that
what
I agree with that.
I
I'm
think
not
I
so
think this
sure
is
I
where we
can agree with that,
disagree
Alex.
because I think I agree with that
Yes, but if
entirely.
you agree
But
with that, then you have to disagree with my suggestion that I made a few minutes ago, which is that the COVID-19 pandemic brought about something similar.
yeah,
It got to a point where it was no longer immediate or sudden, but yet
yeah.
you accepted that the emergency powers exercised thereunder and the
Well,
states of emergency declared were still valid. So
yeah.
you
But
can't you
the
can't
difference,
you can't
I think
agree
the
with one
difference
and
for
disagree
me,
with another.
the difference for me, if I, is that the COVID-19 pandemic regulations, in large part across the region, were done through public health ordinance, right? So they were already done through instruments of legislation. So entirely different context,
Sir,
right?
let us not go there.
The,
Let us not go
the,
there. Because
but
you're
yeah,
about to tell me that the source, you're
but let me,
about to
no,
tell
but
me that
let
the
me,
source of the power makes the difference, which is
no, I'm not
completely,
saying
as
the
you know,
source of the
Mr.
power makes a
Ramnas.
difference, right? I'm
So
not saying
what
the
are you
source of the
saying
power
then?
makes a difference. But you can't cut me off before I go on my elaborate explanation.
I thought you were finished, actually.
No, 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 right? Um, so I do agree in principle, right, that there are situations where an emergency power can extend for a long period of time if the emergency persists, right? So had regional governments called the COVID-19 pandemic under the emergency powers provisions of their constitutions, I do see as a matter of convenience the need to change emergency regulations as the crisis evolved. Now, remember, if you remember back to the pandemic, the emergency regulations were not entirely homogeneous. They changed according to the situation that was presented monthly. So in Trinidad, for example, on some months, the regulations would allow you to go to the beach, on others it won't. On some months, you'd have rules on number of people on a maxi taxi, and that might change on an evolving basis. And in that respect, where the emergency is long-standing and that there is a need for consistent subvention of the separation of powers in the parliamentary process, then I can see a situation where going to parliament, extending the emergency, and recognizing that emergency powers exist for this long period of time is legitimate. In the situation of crime and no discernible or identifiable reason being given why these emergency powers are needed, because nobody has said that there's a declaration of war against the state by these gangs. Nobody has said that these gangs pose some fundamental threat to the existence of government. Then I don't see the need to
But
have.
but but those are not the only circumstances in which states of
I'm aware.
emergency can be
Yeah,
declared.
I know, but
Right.
what I'm
So
saying
it
is that
could be of such
so
it
you
could
are
be
throwing out a red herring on an example I gave. This makes no sense. You are throwing out you are right.
Alex,
You are throwing out a red herring.
all
And
I'm saying, right? If we go to your country's constitution, for example, all I'm saying is this. We go to section 8(2) of your
yes,
country's constitution. And it says it could be where war has been declared or is imminent. It says it could be if there's an earthquake, hurricane, flood, fire, outbreak of pestilence, or infectious disease, any other calamity. And then it says where there is a situation of such a nature and on so extensive a scale that is likely to endanger the public safety or to deprive the community or other substantial portions of the community of supplies or services essential to life. Can the insurge or increase of gang related activity and gun violence fall under that last category? Can
sir,
it not? Yes or no?
sir, this is why I'm saying you are throwing
Yes
out a
or
red.
no,
No,
Alex?
this is
Yes
not
or
no,
no?
Mr. Yehood, please stop, right? You are responding to a question you did not ask me. You're asking me to answer a question you did not ask me, right? You asked me to address the reasoning in Dayton Campbell about extending a state of emergency or the existence of emergency for a very long time, right?
Right, but that
I am
cannot be looked at in
highlighting to you
isolation.
just now, I am highlighting to you my reasoning and squaring the reasoning Dayton Campbell with the COVID-19 pandemic. And I am saying that there was a reason in the pandemic why I think it's necessary for that emergency, because I have not disagreed that crime could never be a state of emergency,
You've
right?
never, okay, good.
I have not
Once we can
disagreed.
agree on that.
I have
Fair
not
enough.
dis that was not an argument we were having, right? What I'm saying is that the practice of using crime as a justification for elongated or several successive states of emergencies is not tenuous with cogent constitutional reasoning, because
Okay.
there's a difference between a pandemic that evolves weekly and new strains were coming up and new treatments and new outbreaks and different zones of things and different identified hotspots and whatnot and all these things that we had to deal with 5 years ago. And crime,
Well, I mean,
especially crime in the Caribbean, as it has been articulated to us by the regional governments in their reasonings. If you pay attention and you read the proclamations and the parliamentary speeches by the various attorney generals saying why they call these states of emergencies, nobody says that we are in a situation of grave imminent danger, that these gangs have the capacity to overthrow the government. At most,
yes, but
there's threat of
that
an
is
attack.
not that
Right.
is not the
And what no
standard.
no
That
and
is
what
not
no
the
Mr. Yearwood,
standard.
stop, please. You're responding to things that you've asked me a question and you're responding to something else. I'm not talking about the standard, I'm talking about time. And I'm talking about the circumstances in which time and the need to have an elongated state
So
of
is it
emergency to
safe
fight
to
crime
say
would
then?
exist. You
Is
are
it safe
throwing
to
out
say
red
that you're
herrings.
fair enough? Are you saying then, Alex, that your argument is more or less an evidential one? You must
It
come with
is an
evidence.
is an evidential one, which is what
Okay.
the court in Eli said, but not so much. And
Okay.
even if it's an evidential one, I think the type of evidence you have to bring, I have a disagreement in how the court treats the evidence. Um, but to finish my point, um, because you keep on interrupting me to introduce the standard, which I was not talking about, sir.
Sir, that is the purpose of this podcast, is to have an informal discussion, not
Session
monologues, to have dialogues.
monologues.
And you
So,
know I will play the devil's advocate. The same way you
you
do
know,
when I'm
you
trying
know,
to
I
make
am
a
a,
point.
I am a sucker for a good Shakespearean soliloquy. Okay.
But I know we have to come to the end of this particular part of the episode soon, and I say part because, as you
Yeah.
indicated earlier, we have different parts of this episode coming. But you mentioned Trinidad, and you mentioned the case of Earl Ely, which happened years ago, but now Trinidad has found itself in the same, if not similar, position. So, just to give our listeners, even though I'm sure that they'll be familiar with the situation by now, because I think at this point the entire Caribbean is watching on to the developments in Trinidad. So, we had a situation months ago where CCTV footage captured an incident involving the police and these two civilians. And the footage shows that the police got out and they riddled the vehicle that the civilians were in with bullets. Regrettably, the driver, who was the guy, he succumbed to his injuries and he passed. And the girl, who was his girlfriend, she, I think, is now partially paralyzed or something like that and is receiving treatment overseas. Now, after all of that, the police reveal to the public that they are bringing charges against the girlfriend, even though she sustained injuries and there's no evidence. Well, based on the CCTV footage, we don't know what the police is going to come with, but there's
Yeah.
no evidence that we can see with our human eyes suggesting that the girlfriend contributed to the death of her boyfriend in any way. But they're bringing charges against her for, I think, what is it, Alex? Is it
Manslaughter. So to add
manslaughter?
context, yeah. So what the police has indicated in their statements was that it was a police chase. That is not in dispute. They are indicating that there were shots fired. The video doesn't suggest that. Um, from
Yes.
me looking at what I have seen. Um, but
But
the,
again,
yeah,
the CCTV footage doesn't capture the entire chase either. So I don't know if they have evidence from
but
before which was not captured
uh, as
or
a
you know.
as I say, that is a matter for the courts. But what
Yes.
it raises the question and why we bring it up is that because recently in Trinidad, as everyone would know, there have been protests,
Peaceful
peaceful
protests.
protests
As far as I
in
know, none of the
relation,
protests has
yeah,
resulted in any
yeah,
violence, any
yeah,
retaliation, anything like that. All of the
right.
protests, as
And
far as I know, Alex, you correct me
yeah,
if I'm wrong, have been peaceful.
they've been peaceful, right? And what we have happening, remember, these states of emergency were called with the specific purpose of curbing gang violence and reducing crime. And what we have now evolving is the use of these emergency powers as a means of silencing and, in some ways, breaking up and suppressing the protests. And it goes to what the purpose of this series or this season two of the podcast will begin with is on a discussion of the legitimate aim of the exercise of these emergency powers and the
Correct.
dangers or the inherent dangers that come with emergency powers. Because it is, I'm not sure if we made it very clear in the beginning, and I hope we do, but the declaration of emergency and the suspension of rights, even temporarily, is a serious thing. And if not exercised responsibly, as it has not been done in Trinidad, you run the risk of reaping authoritarianism and the emergence of what appears to be a police state. And that is just the reality of what misuse of emergency powers can bring. I preface that by saying that
And
these emergency powers haven't been going to court, and that is a statement of opinion. But I think, I think I think it's quite clear to anybody who logically appraises the situation that the peaceful protests in no way can be connected
to gang
to
violence.
gang violence, at least on what the public knows. Unless the state comes with some miraculous piece of evidence that we're missing.
But as far as I'm aware, Alex, are and I'm asking this out of genuine curiosity, are there any curfews in Trinidad right now?
No, there's no curfews.
Right. So my thing is because a peaceful protest or any protest to begin with has to be founded on the exercise of freedom of movement.
Yes.
Now, if you're saying, which is a constitutional right, which is a human right, fundamental basic human right. Now, if you are telling me that you cannot have a peaceful protest, then I should not even be able to go outside and walk to begin with. There are no
Yeah.
curfews, no limitations on freedom of movement, but yet you're telling me I can't walk to protest.
Yeah.
Because all a protest is movement plus display or expression. The
Yes.
display would come from placards, the expression would come from chants, which is what was happening in Trinidad. The, you know, sounding of your voice, saying whatever you want to say.
Yeah.
You would then have to come and show me that somehow, as you said correctly, Alex, and as you said, it's just your opinion, but I think your opinion carries a lot of weight and validity here because I agree with you, right? Uh, you would have to come and show me that somehow by engaging in peaceful protests, these civilians are contributing, inciting, or somehow aiding and abetting um, criminal activity or gang violence, something like that. And I just don't see the correlation because there's none. Not even remotely is there a correlation between peaceful protests and the upsurge in gang related activity or gun related activity.
Yeah.
So to my mind, it doesn't even get past the first prong of the proportionality test that
Yeah.
we spoke about in other episodes of this podcast. But it is quite horrifying to see that this is the state of affairs in Trinidad. Right? And it really begs the question, Alex, just to wrap up this particular part of the episode. Where do we go from here? How do we balance protecting the safety of the public and national security on the one hand, and protecting the rights and freedoms of the individual, which are enshrined in our varying Caribbean constitutions on the other? How do we do that going
I think
forward in the context or climate of increasing gang violence, which is something that plagues all of our Caribbean countries?
and I think this is why I tend to agree with Dayton Campbell a bit more. Not for any judicial reason, any deeply judicial reason, but in a more philosophical sense or a more uh, an understanding that when the court tries to engage in what it engages in early line, Dream Stain, in Southern Highlands and Sumatra, which is a Papua New Guinea case that both these cases cite. Um, when they try to dance the line between judicial deference and executive power to declare a state of emergency on something as arbitrarily defined as crime, what you're doing, or a rise in crime, I should say, is what you're doing is you're opening a door for the situation that exists in Trinidad as it is right now. You're opening a door in a more, to me, in a more scary sense or a more drastic sense, the situation that exists in El Salvador, where you are creating conditions that allow a state or a government to manufacture a state of circumstances that allows one, the suppression of protest, the indefinite detention of persons, the the arrest without warrant, these things that are constitutional norms. You create circumstances that lead towards a police state. And to me, that door opening, that that door opening exercise that the court engages in Eli and Stain, that you kind of dance this dance of, we're not saying in all circumstances crime could never be a state of emergency, um, is dangerous. And it's dangerous because it leads to what we have now, in that the state will never disclose its intelligence on what it says is a threat to high-ranking members of society or all of these things. It's not within their remit to disclose their intelligence. They just have to say they have intelligence. Intelligence can be fabricated. Again, statement of opinion, but also quite true. Um, so this is where I come from. I come on this line, and it's not opinion based on any sound judicial reasoning, but uh, a, a great a great concern for the consequences of trying to be, for want of a better word, colonial in your judicial reasoning, and paying deference to constitutional norms and established judicial norms, and ignoring the realities of the society that you live in.
Okay, and I tend to agree with you, though I was being devil's advocate throughout the
Yeah.
entire episode.
I
But
love
I
how you have
actually
to come
do
to the
agree
end to just let
with.
people know.
Yes, of course, you have to keep the discussion stimulating throughout. But now that we've reached the end, I must say that I do agree with you, and I tend to agree with the reasoning in Dayton Campbell for the most part. I like how the court went as far as to say that just because normal or traditional policing methods or measures are no longer viewed or seen as effective in dealing with gang related activity or the increase in criminal activity does not necessarily mean that you can now come and utilize emergency powers in perpetuity or forever to deal with that criminal or gang related activity. At some point, it must come to an end because the reality is there are so many other things sometimes you can do to actually curb the increase in gang related activity. And we know what some of those things are. The politicians themselves know what some of those things are, but they just do not want to do them. So they would rather have the knee jerk reaction of declaring a state of emergency than to address the root causes of
Yeah,
crime and the increase of that crime. And I do agree with you that if it is that you're going to come and say that something has reached the scale or is of such a nature that it now threatens the entire sovereignty, security, or life of a nation, that you must come with something more than just a bald statement that you have evidence or intelligence suggesting that this is happening or this is about to happen or that increasing criminal activity is going to cause the entire political, judicial, legal, and societal order to crumble. Because the reality is, as you correctly said to Alex, then we go from a constitutional democracy where, as we know it, to then a state of emergency where there's an abuse of power, an arbitrary exercise of power, as seen as in Dayton Campbell, where not just rights and freedoms now are being trampled on, which is serious, but then it gets to a point where the separation of powers, where a government is trying to evade constitutional parliamentary procedures to get a state of emergency declared. And I think that that is very scary. It's quite worrisome for me, and we really need to be more vigilant. We need to pay close attention to these happenings, and in some instances, we need to challenge them constitutionally and take the matters to court. And I do believe that more of these matters will go before the court because crime in the Caribbean is something that is perennial and is just not going to disappear at any given point in time. So it's something
Yeah.
that we have to continue to deal with, but I don't think that the proper or right way to continuously deal with them, unless the situation gets out of control to the extent where the life of the nation is threatened so badly that a state of emergency needs to be declared.
Thank
And
you for
then you have many instances where the gang related activity or the criminal activity is so concentrated in one particular parish, one particular region, one particular community. And then sometimes a state may want to declare a state of emergency for the entire nation.
yeah.
And that
Well,
is completely
yeah.
disproportionate
Well,
and
actually,
unacceptable.
actually, to end on my point, because this is how I was going to close. I think, as mentioned in that point, but in a different context, is that I think as a Caribbean, there are certain facts, certain realities we need to accept. We need to accept that there are communities across the region and every country that are marginalized, that have a proliferation of marginalized youths that are drawn towards a life of crime. It could be very varying reasons, socioeconomic, parental, all of these things. And this is not new, this is a fact. These 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 groups, these regions, these areas have proliferation of gangs. These groups, these areas have members of our society who are already a minority in the sense that they have in some way been forgotten or disenfranchised or not appropriately treated and has led them into this gang life. Um, and the practice of declaring states of emergency to address crime inherently, by its very nature, says that the only way that we could treat with the problems that affect these areas and and that cause this problem in all our countries is to suspend the rights of these marginalized peoples, these marginalized groups. Um, and to me, it's just, again, in a philosophical, not entirely reasoned judicially sense, that just feels inherently unconstitutional and opposite to what your Bill of Rights was created for. And I think with that, unless Rico has anything to say, we could set up our next part of this podcast, because this is a multi-part podcast of season 2, where we would invite one of our a guest from one of the islands that we spoke about today to elaborate on the situation in their country and get their perspective on the declaration of states of emergency to address crime there.
Yes, and thank you so much, Alex. And we're not going to tell you which country we'll be discussing first. That will be a surprise. But until we meet again, guys, thanks for joining us for another episode of the Public Law Parlor.
Another
And we
season of
will
the Public Law Parlour.
another season, but with a new season comes a new episode. So another season and episode of the Public Law Parlor. And we will see you next week. Take care.
Take care. Bye, guys.